And you're charged with evading arrest detention with a vehicle. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Welcome to the Court of Justice.
Court is calling 2022 CR 10402, State of Texas versus Alicia Small. Can I have parties announced for the record for the state?
Daniel Escobar for the state of Texas.
Defense?
State.
Are you Ms. Small?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Sure.
Court will find that the state is in compliance with discovery. Ms. Small, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it? And did you sign it? Next, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Sure.
State, are you proceeding on the indictment as presented?
Yes, Your Honor.
Ms. Small, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places? Did you understand you're charged with evading arrest detention with a vehicle? That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand? If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand, Mr. Simmons?
Sure.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights? And did you intend to give up those rights and enter into a plea in this case? Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison and up to a $10,000 fine? Did you understand?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
In my opinion, she does, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Ms. Small, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
And just like that, one of the most fundamental rights in the justice system, a jury trial, is gone. Waived. That means no group of peers, no deliberation room, no second opinions. Everything now rests in the hands of one person, the judge. This decision speeds things up, sure, but also raises the stakes dramatically. Because now, every answer Alicia gives carries even more weight. Do you think giving up that right was a smart move or a risky shortcut?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it? According to the plea bargain agreement, there's a $1,000 fine probated and the state recommends deferred adjudication. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
Yes, Your Honor.
State, is that the plea?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places? Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Can I have parties approach?
Yes, sir.
All right, I'm showing you what's outside the agreement. The state is requesting that your community supervision be for a term of 2 years and there be 200 hours of community service restitution. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State, any evidence?
Your Honor, state offer states is for one and all attachments.
No objection.
All right, Ms. Small, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same.
This is the turning point. The judge has reviewed the evidence. No witnesses, no dramatic cross-examinations, just documents, statements, and reports. And it's enough. Guilty. But here's where it gets interesting. Instead of immediate punishment, the court shifts toward deferred adjudication. That's not freedom, it's conditional mercy. Alicia isn't being convicted today, but she's walking a tightrope. One misstep, and the full weight of that felony comes crashing down. So now the question is, can she handle that pressure?
All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, sure.
Anything you wish to say on behalf of your client?
We pray that the court follow the plea agreement. We would also ask the court, she's fallen on some hard financial times, so we'd ask the court to consider probating a portion of the fine and give some consideration to her possibly being able to get credit for some of her community service via employment and or education.
All right. Do you have any children? What are their ages?
10.
Just one? And is your child living with you?
No.
Where's your child staying?
In Indiana.
And who is your child staying with in Indiana?
His father.
When you're drug tested today, what are the results going to be?
Negative.
Have you ever used drugs? What?
I've used narcotics, pain pills.
When's the last time you used pain pills?
Oh, it's been a couple years.
Now, the courtroom shifts from legal facts to personal reality, and this is where things get uncomfortable. The judge isn't just evaluating a case anymore. She's evaluating Alicia's life choices. A child living out of state, over a year without contact, past drug use. These aren't just details, they paint a picture. And in a courtroom like this, perception matters. A lot. You can feel the tone changing, right? This isn't just about a crime anymore. It's about accountability as a parent and as a person. What do you think the judge is seeing here?
So why is your child with his father and not you?
Because his father lost his job. They got the best child custody lawyer. My house caught fire just here recently, and his dad just took up and left. He didn't have a job. He lost his job. He couldn't find another work down here. He has more family back home, so he took him and left.
So when's the last time you saw your child?
It's been over a year.
Okay. So are you employed?
No, ma'am.
So how do you support yourself?
I stay with my boyfriend.
And who is that?
Esteban Rivera.
And what does he do for a living?
He's a manager at electrical company, Blue Country Electric.
All right. This is what the court is going to do. The court is going to sentence you to 2 years deferred adjudication. I'm going to want a UA today. I'm going to want a TAP evaluation. Follow the recommendations of TAP. If TAP says inpatient treatment, we're going to start with outpatient treatment. You're going to have to get employed. Proof of employment within 30 days. And there's a lot of seasonal work going on now. So proof of employment within 30 days, no employment as a home health care provider or with minors. And the home you live with, is it just you and your boyfriend?
His 2 sons.
How old are they?
They're in their 20s.
Okay. 200 hours of community service restitution. 40 of those hours will be waived if you.
Here it is, the sentence, and it's layered. Deferred adjudication, strict supervision, drug testing, employment requirements, parenting classes. This isn't a light consequence. It's structured pressure designed to rebuild discipline. Even incentives like reduced community service for vaccination or completing classes show the court is pushing for behavioral change, not just punishment. But let's be real. This kind of structure can either help someone rebuild or overwhelm them completely. Do you think this is a fair second chance or too much to handle?
Provide proof of the COVID vaccination. Court is not requiring you get the COVID vaccination, but if you do, 40 hours will be waived. I'm going to ask for parenting classes with Triple T. Once you complete that, the remaining of the community service hours will be waived. There's to be regular reporting by Zoom or in person. I'm going to want field visits 2 times per month until further notice. And probation, if you want to count the field visits as her reporting, you can. And we are going to do the UA hotline until further notice. And we'll start off with UAs once a week. And then if there are no issues, you can taper that down. Probation is calling 2020 CR 10202, State of Texas versus Mark Reyes. Could I have parties announced for the record for the state?
Oscar Salinas for the state of Texas.
For the defense?
Lorraine Ephraim for Mr. Reyes.
And counsel, can I see it for a moment? And are you Mr. Reyes?
Oh, yes, ma'am.
Mr. Reyes, did you have a chance to review with your attorney what's entitled motion to enter adjudication of guilt and revoke community supervision?
Yes,
And first amended motion to enter adjudication of guilt and revoke community supervision?
yes, ma'am.
Are you the same Mark Anthony Reyes who was placed on deferred adjudication in 2020 CR 10202 for the offense of unauthorized use of a vehicle on May 4, 2021 for a period of 4 years? Is that you?
Yes, ma'am.
All right, state.
Yes, violated condition number 5 in Bear County, Texas. The defendant, Mark Anthony Reyes, did then and there fail to report the supervision officer as directed for the month of October of 2021 in violation of condition number 5.
How do you plead to that? True or not true?
True.
State,
State waives the remaining allegations.
any objection to the waivers?
No, Your Honor.
Mr. Reyes, did you understand by pleading true to violation? Sir, you need to take a seat. Yes. All right. Did you understand by pleading true to violation of condition number 5, the court could find it true, grant the motion, find you guilty, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine?
Yes, ma'am.
Knowing that, do you still wish to plead true to violation of condition number 5?
Yes, ma'am.
Court will find violation of condition number 5 true. Is there an agreement?
Yes, Judge.
No.
Oh,
No
there's not.
agreement.
Oh, I'm sorry.
Sorry.
I misunderstood, Daniel. Then my apologies, Judge.
Maybe-
There's not an agreement.
Maybe I didn't communicate it.
All right. So state, what are you requesting?
Okay, the state would ask this court to grant the motion, revoke defendant's community supervision or deferred adjudication and sentence him to 18 months in the state jail facility.
All right. Defense, what are you requesting?
Your Honor, Mr. Reyes would like an opportunity to be reinstated or continued on probation. And I think he would like to address the court directly if that's okay. His situation has improved dramatically. That's one main thing he wants the court to know, and he thinks he's in a much better position now to be successful on probation than in the past. He does owe, from what I understand, quite a bit of restitution on the case.
$8,000.
And he believes that he can be gainfully employed here, that he has a job waiting for him. And he wants to and intends to at least make some progress in payments on the restitution. I don't think anything's been paid to date.
And the court wants the restitution paid.
Yeah. But Mr. Reyes, is there something that
You
you
want to raise your right hand? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
You can lower your hand. What would you like to say?
I just want to say, as far as the probation win not reporting, I don't know if you remember, whenever I got probation, I was living in Atascosa County, in Lido, Texas. So there was no way I was able to hop on a bus and go report and go do drug tests all in the same day. But now I do have a place to stay here in San Antonio. I have a job waiting for me when I get out. And I just have a better environment now. That's all I want. For the court to know.
where would you be employed, you believe?
I do have an electrical apprentice license. I gained that when I was on probation. And somewhere in the electrical field.
I don't understand your saying about the reporting, because I ordered regular Zoom reporting or in person. So you can report by Zoom or in person.
Yeah, well, there were several times that my probation officer wanted me to meet with him in person, not through the Zoom.
Okay. All right, State, do you have any questions?
No, just argument.
All right, so With regards to the $8,000, if I were to continue you, how much money is he going to be paying towards this $8,000 that he owes?
Well, he's been in custody for about 200 days total. So at this time, I don't think, do you have any funds that you could pay down?
I actually do. My girlfriend, I don't know if this matters, but she had gotten into a car accident recently and the insurance had granted her some money. And
Oh, you shouldn't be using her insurance
no,
money.
I have stimulus checks coming in.
All right, so here's the thing.
Yes, ma'am.
I don't think people should be using other people's insurance checks to take care of themselves. That's for that person.
Yes,
And I
ma'am.
don't think you should be asking for that because you need to pay that because
I
otherwise
did-
you don't learn your lesson.
Do you
I-
actually have stimulus checks waiting for you?
They should be hitting any day now.
You're
according to the-
expecting them?
Yes, according to the H&R Block, my girlfriend has my debit card and
I didn't get a stimulus check.
I'm getting 3 of them.
Well, I don't even think you should mention you're getting 3. I'm getting 0. I got
sorry.
0.
Well, how much would you be able to pay down towards that restitution? Do you think you'd be able to pay 500
I'll
or
be able to pay
1,000?
more than, I'll be able to pay $1,000, man.
All right, State, what are you requesting?
At this point, still revocation, Judge. If you made an agreement with this court to be on supervision, has violated that agreement. And again, the court pointed out correctly that one of the easiest things being on supervision is to simply report, and even gave him the opportunity to report via Zoom. He failed to do that. Again, he's stating that there was requirements to be made in person. However, I don't know whether that was conveyed that he was unable to. But again, you have someone who's on probation who is clearly demonstrating that he's not a successful probationer.
Right, is there something you wanted to add?
Oh, Judge, he was reporting on Zoom. The last appointment was on September 17, 2021, in which his officer indicated he needs to take probation seriously. Mr. Reyes at that time then said it's all too much for him. He just wants to do his time.
Okay.
He may have said that in frustration, but he's been in custody now for almost 6 months. Maybe 200 days was a little over.
All right, so I'm gonna give you a choice. Sometimes I can give people choices, sometimes not. And the only reason why I'm giving you this choice is because there's $8,000 that's owed to Mr. Garcia. And Mr. Garcia needs that $8,000 to help make him whole. So I can give you the 18 months that the state is requesting, and you'll get credit for any time served that you've been in custody. Or I will continue you. I'm going to extend you and you're going to pay that money. And if you don't pay that money, we're going to be right back here again.
May I speak?
Yes.
I would want to get reinstated.
Okay.
Continue, please, ma'am. And like I said, I do,
Continued and extended.
yes, continued and extended, and I will pay that money. And report. And I will be living in Bear County city limits, so I'll be able to get there. If it's needed to be in person, you know.
And the record reflects
Yes, ma'am. Yes,
Tell her
ma'am.
that.
made a statement that there's
I'll do it.
income that's coming that's outside of his normal income, that so there's the income that should be paid towards restitution.
Okay.
I'll do whatever it
Second chance. Her future hanging on compliance. Meanwhile, another defendant faces the consequences of failing probation, but is still given one last opportunity to make things right financially. This is the balancing act of the justice system. Punishment versus rehabilitation. Judges like Stephanie Boyd aren't just enforcing laws. They're making calculated decisions about people's futures. So what's the takeaway here? Accountability isn't optional. Whether it's showing up, paying restitution, or proving you can change. The system gives chances, but it demands effort. If you found this case as intense as we did, drop your thoughts below. Who do you think handled their situation better? And don't forget to hit that like button, share this breakdown, and subscribe for more jaw-dropping courtroom moments you won't want to miss.
takes, Judge.
All right, the court will deny the motion, extend you for 1 year. When are you going to have this $1,000 lump sum?
As soon as the money comes in, like I said, my girlfriend,
Do you
they
think within 10 days?
within days, within 10 days, I
You
will say
think
10 days.
10 days?
Yes, ma'am.
But
All
then
right,
we'll put it-
$1,000
or
restitution.
by December 31st, maybe. Today's the 15th.
All right, no, this is what I'm gonna do.
Okay.
There's $1,000 lump sum to begin with towards restitution. That is to be paid no later than January 9th.
Okay. That's it. Thank you, Judge.
And then thereafter, how much are you able to pay per month?
Or it's as,
No. It's a figure.
I can pay, what is $100 okay? 100, 200?
How much are you expecting to earn from your job?
Oh, okay. Well, I'll probably be getting about 600, 700 a month. Every paycheck.
Is that every 2 weeks? Or every
That'll
week?
probably be every week.
All right, you're gonna pay $250 per month
Okay,
towards restitution. So probation, he's to pay $1,000 towards restitution by January 9th. Thereafter, he's to pay $250 a month to restitution. I'm gonna want weekly reporting by Zoom until further notice. I'm gonna want him employed within 15 days of release. Again, no employment as a home healthcare provider or with minors. I'm gonna want field visits one time per month until further notice, and probation, if they want to count that field visit as reporting, they can. And I want the restitution prioritized. All right, is there anything else from either side?
Your Honor.
All right, thank you.
Thank you, Judge. May we be excused?
Yes.
Judge Stephanie Boyd looked past the plea papers and straight into Alicia's life. The charge was evading arrest with a vehicle, a third-degree felony. But the judge wanted to know one thing. Where's your child? Alicia froze. Her son wasn't with her. He was in Indiana, with his father, and she hadn't seen him in over a year. Then came the confession. Have you ever used drugs? The judge asked. Alicia admitted to narcotic pain pills. The last time? It's been so, she trailed off. Judge Boyd didn't wait for an excuse. She accepted the 2-year deferred adjudication, but on her terms. Immediate drug test, TAP evaluation, outpatient treatment, proof of employment in 30 days. No working with minors or home health, parenting classes, field visits twice a month. The state's soft recommendation crumbled. Alicia stood silent, realizing this wasn't mercy. It was a cage of accountability. Judge Boyd didn't destroy her future. She destroyed every escape route and made her earn her way back to her son.